Sure, yeah. Hi, everybody. Good afternoon, and welcome to our first edition of our Building Better Business webinars. We created this series really in order to bring our business owners into 2021, since a lot of people, myself included, are just really over 2020 at this point. So today we are going to be talking about the CT Paid Leave Program and what that means for you, your business, your employees, and your family. So thank you, Andrea Barton Reeves, for hosting our call today. And if you have any questions, again, please type them in the Q&A or the chat box, and we can hopefully get to those after Andrea is done. If you are not a speaker today, if you just have your camera turned off, that would be great. All right, Andrea.
Great. Thank you, Luke. So thank you for the opportunity to be here today. If I could ask everyone to use the Q&A exclusively for your questions, because that way it allows Amber Forrest, who's here with me from the Paid Leave Authority, as well as Andrea Comer, to answer your questions directly. It's a little more challenging to do that in the chat because it's not really designed for that purpose. So that would be great. And then we will answer questions at the end of the presentation. So I'm going to go ahead and share my screen. So we'll start there.
You are good to go.
Thank you. All right. I'm going to start in slideshow mode. Here we go. All right. So today we're going to learn about the Paid Leave Act. And just a little bit about me. My name is Andrea Barton Reeves. I am the president and CEO of the Paid Leave Authority and CEO of the Paid Leave Authority. I came to the authority from HARC, where I supported people with intellectual disabilities and their families. I have an undergraduate degree in English and a law degree from New York Law School. So today we'll have an overview of the Paid Leave Program, its key dates, the law itself, what it looks like when you're applying for paid leave benefits, the role of the employer, putting that into practice, additional resources, and questions and answers. So the authority itself is designed to serve a growing need for families so that they can have some financial relief when they need to take time off for a qualifying reason to take care of themselves or their loved ones without having to worry about lost income. And we do that through a twofold mission, and that is by providing the pathways to accessible paid leave, and also to help employers and administrators and healthcare providers by offering tools and support so that they can navigate the program. We have 5 primary responsibilities at the Paid Leave Authority. One of them is outreach and engagement, so thank you for having us here today. The other is to develop the policies and the procedures that are needed to run the program. Third is establishing the trust fund contribution rate, which by statute is 0.5%, and receive those contributions. For those employers that wish to offer their own plan, rather than participate in the state plan, we approve and audit those private plans. And finally, we administer claims for paid leave benefits. So which employers are covered by the paid leave statute? Those employers include those that have one or more people working in Connecticut, including nonprofits and private sector employers that have a unionized workforce. Sole proprietors and self-employed individuals who choose to opt in may do so, but if they do so, they have to remain in for a minimum of 3 years. Those who are not covered include federal government employees and some state of Connecticut employees, except those that are covered public employees. Those that work in municipalities or local or regional boards of education are also exempted unless they too have covered public employees. The category of employer that is completely exempt are non-public elementary or secondary schools. So what exactly is a covered public employee? They are the non-unionized employees of the state of Connecticut, as well as those unionized employees who collectively bargain to be included in the program. Employees of municipalities and local or regional boards of education can participate if the unionized employees of those workplaces collectively bargain to be included. And if they do so, then everyone who either works for the municipality or the local or regional board of education will be included in the paid leave program. A municipality has a very broad definition, as you can see at the bottom of this slide. It can include a town, a city, or borough, but it can also include a tourism district or a commission. So we know that come January 1, 2021, employee contributions will start to be collected by employers. And here's what happens to that money. The employee contributions of 0.5% of wages are collected by employers, and those employers remit those wage contributions as well as accompanying wage information. We collect the contributions and we validate the information using resources available to us from the Department of Revenue Services and the Department of Labor. Those contributions are deposited into the Paid Leave Trust Fund, and that trust fund is used to pay benefits in 2022. Key dates that are important for you to know are these. The website launched on September 4th, and it has an enormous amount of information for employers, employees, sole proprietors, self-employed, and third-party administrators, so that all of those categories can understand, of users can better understand the program. We're asking all employers to register now. Self-proprietors and self-employed individuals who choose to be a part of the program may also register now too. But remember that their participation is voluntary. Employers are asked to register so that we're aware and that they're aware of their obligation to withhold contributions starting January 1 of 2021. And employees and sole proprietors and self-employed individuals will all be able to access benefits come January of 2022. So let's go through a brief overview of the leave laws. The reasons for leave by statute are these. You can take leave to create or expand your family through the birth of a child or the placement of a child with your family for adoption or foster care. You can take leave to care for a family member with a serious health condition or your own serious health condition, which can include being an organ or bone marrow donor or pregnancy. Special leave is available for military families, and that includes the ability to take time off to care for a family member who was injured during active duty, or for qualifying exigency leave so that you can be available and present when a family member is called overseas to active duty. And finally, which is what is unique to the state of Connecticut, there's up to 12 days of leave that are available for those who are impacted by family violence. So let's take a look at what the law will look like when it changes in 2022 versus what it looks like now. Our current family and medical leave law applies to employers with 75 more employees. And those employees had to have worked for their employer for 12 months and at least 1,000 hours in the 12 months immediately preceding the time that they would be eligible for leave. Once they do that, they have job protection after 12 months, and then they would be eligible to access 16 weeks of leave in a 24-month period, with that period being much longer and available for military caregiver leave. And the employer could require the employee to exhaust all of their accrued time off in order to cover the time that they're away on medical leave and family leave. In 2022, much of this changes. The law now will apply at that time to employers that have one or more employees. There will be no hours worked requirement, and job protection will be available after 3 months rather than 12. Employees will be able to take up to 12 weeks off in a 12-month period for all of the leave reasons I noted earlier, with the exception of the 26 weeks of leave available for a military caregiver, with only 12 of those weeks being paid, however, and an additional 2 weeks of leave might be available for incapacitation during pregnancy. And another important change to the law is that an employer can still require an employee to use their accrued time off, but they have to allow the employee to keep up to 2 weeks of their accrued leave. With respect to job protection, there are laws that currently exist, and they include the Federal Family and Medical Leave Act, to which there are no planned changes, workers' comp, the Americans with Disabilities Act, Pregnancy Disability Act, and the Connecticut Fair Employment Practices Act. And those all remain viable laws in the state. What will change, as we know, is that effective 1/1/2022, the Connecticut Family and Medical Leave will apply to employers with one or more employees. In addition, that act will also provide income replacement while on leave, but workers' compensation will remain available as well. What's important to know is that a person who is on workers' compensation and receiving benefits is ineligible to receive benefits from the Paid Leave Authority at the same time. The primary difference between the federal medical leave and the state leave in 2022 will be the expansive definition of family. Right now, under the federal statute, you can take time off to take care of a parent, a spouse, a child who's under 18, or one who's over 18 and has a disability. This will change, and the law will allow for care for a parent, a spouse, a son or a daughter, regardless of their age, a sibling, a grandparent, a grandchild, or an individual that's related to the employee, either by blood or affinity, that has a close relationship that's equivalent to these family relationships. What exactly does that mean? Related by affinity has a specific definition, and that is any person with whom the employee has a significant personal bond that is like a family relationship, regardless of the biological or legal relationship. And of course, that is dependent on the situation. So, for example, let's look at the second bullet from the bottom, where an unmarried significant other of the employee with whom the employee may live and has a familial spouse like relationship, they may be living together. That person may need care, maybe they're having surgery, they have other serious health condition. As the law currently exists, there is no opportunity for that person to take time off to care for their significant other if they are not married to them. That would change under the law in 2022. So what are the lengths of leave? I alluded to them earlier, but here they are more specifically. The federal, as I mentioned, will remain unchanged with 12 weeks in a 12-month period, with the exception for military caregiver leave. FMLA in 2022 for family and medical leave in the state will be 12 weeks in a 12-month period. Again, accommodation for military caregiver leave, 12 weeks for family violence, and an additional 2 weeks for incapacity. The paid leave benefits will also follow that same leave cadence. Eligibility for paid leave and for job protected leave looks like this. Federal remains unchanged with the same requirements for hours worked and the amount of time worked. For Connecticut, job protected leave, you have 3 months of work with the employer and a no hours worked requirement. In order to access paid leave benefits from the Paid Leave Authority, you will have to have earned $2,325 in the highest earning quarter of the first 4 of the 5 past quarters. And you are either currently employed and working in the state, or you had been employed and working for the immediate 12 weeks prior to your time that you're asking for leave from the Paid Leave Authority, or you're a sole proprietor or self-employed who's opted to participate in the program. What is the role of the employer when an employee comes to them and asks for leave? Every time the employee asks for leave, we tell employers, please ask yourself 2 questions and engage in this 2-part analysis. First, is your employee eligible for any job protected leave under 1 or more statutes, including the new FMLA that'll come up the year after next? And if so, whether or not they're eligible for any income replacement while they're on leave. And you should really ask both questions each time. And here's why. Because an employee can be eligible for federal only, for state only, for both running concurrently, for neither, but possibly other job protected leave as a reasonable accommodation, like the Americans with Disabilities Act, or perhaps no job protected leave at all. Again, here's a reminder of what the eligibility is for job protected leave for federal and for state, with the hours worked requirements and the change in the law that will come into effect in January of 2022. And also, again, applying that analysis, asking whether or not the employee is eligible for other job protected leave, the ADA or PDA or SEPIPA, as we call the Fair Employment Practices Act in the state. Some of the things that you should know about income replacement, once you've already asked the question about job protection, is benefits coordination. So employees can receive benefit from the Paid Leave Authority and employer-provided benefits at the same time, but those combined benefits can never exceed 100% of the employee's regular wages. Some short-term and long-term disability policies require that the state benefits be exhausted first. So we at the Paid Leave Authority would engage in benefits coordination, as the first bullet outlines, so that we can make sure that those policy terms are met before people access their employer paid benefits. I mentioned earlier that workers' compensation and paid leave cannot be collected at the same time. But what's important to know is that a person can receive paid leave benefits without having those 3 months of job protection. And the way it would work is this. An employee may be eligible to receive benefits from the authority because they've earned the $2,325 in that base period that we talked about, and they have an eligible reason for leave, and they may have been working for someone right now, or they've worked the 12 weeks immediately preceding their request for leave. Under the statute, they've met the criteria for paid leave. But because they've worked with you or an employer for less than 3 months, they have no job protection. So that dialogue between the employer and the employee regarding their eligibility for job protection, or their eligibility for paid leave, I should say, but no job protection, is an important one to have, and we're going to be encouraging every employee to have that discussion. If an employer chooses to offer a private plan, all the things I discussed are within the purview of the employer. So they will make the determinations around benefits eligibility, time off, required time to be used to cover all a part of their time off. That's all under the employer's purview under a private plan. Finally, with respect to the requiring of the use of accrued time, employers may require employees to use their sick or their vacation or their other kinds of paid time off as long as they have the 2 weeks of leave. If you offer your employees time off in buckets, sick, the vacation, then maybe some kind of personal leave, you can require them to exhaust their sick and perhaps some of their personal, but they have to be able to keep up to 2 weeks of their vacation leave. If you offer just a big bucket of PTO, again, 2 weeks of that leave is available to them. If you have unlimited PTO, which we understand some employers do, then you may have to readdress your policy with respect to how you will apply that, knowing that the 2 weeks of leave need to be available. So how would an employee access benefits from the paid leave authority? The first thing they do is come to you as an employer and submit their application and get their leave approved. We do not do that at the paid leave authority. You will grant their leave and inform them of the time that they have off under the sick or the vacation or the categories that I just outlined, so that they are not leaving without you knowing about it. And you can certainly discuss with them what their options are to get income replacement while they're out on leave. If they decide to apply to the paid leave authority for benefits, they do that themselves. You as the employer are not responsible for submitting those applications. Once we receive them, that employee's eligibility for benefits is determined based on their total earnings from all employers, because we know some people, many people work for multiple employers, and we also determine the reason why they're seeking benefits. The paid leave authority then calculates the benefit amount, but again, we're in communication with the employer, asking to validate their actual absences and whether or not those are covered and the employer knows about it, and to calculate any offsets that the employee may have. And then we calculate the final benefit number and issue those benefits payments. What do those look like? So there are two parts to the formula. If a person is earning less than or equal to the minimum wage multiplied by 40 as their weekly minimum then they will get their maximum benefit based on their earnings. And that is 95% of the employees' covered base weekly earnings, of the covered employees' base weekly earnings. If they earn more than 40% of the Connecticut minimum wage multiplied by 40, which right now is $480, they receive a base amount of $480 plus 60 amount of the part that exceeds the $480 with a maximum benefit of $720. So I have a couple of examples because this is kind of hard to follow in theory. So here's Mike. Mike makes $375 a week, which we know is less than 40 times the minimum wage, which is $480. When we take 95% of Mike's weekly paid benefit, we know that he will receive $356.25 in benefits weekly. Deborah makes considerably more than Mike, and so we then use a different calculation for her weekly benefit. She first receives the $480. Then we take the difference between her weekly wage and the $480, because we're going to take 60% of that number to add to the $480. And in this case, you can see that's $132. So her weekly benefit is $612. Let's talk a bit about how do we put all of this into place in the workplace. So then we have Mr. Coyote, who's worked for Acme Industries, which is a large employer, has 100 employees. He has 4 weeks of sick leave and 2 weeks of vacation time, and he has injured his hand in a non-work related accident. So we know that he is ineligible for workers' compensation. We apply that two-part analysis where we think, well, is he eligible for job protected leave? And if so, how? And income replacement. And his scenario looks like this. Because he's worked for so long, for the 10 years, we know that he's eligible for both Connecticut FMLA, he's worked far longer than 3 months, and federal FMLA because he's worked far longer than a year and has met the hours worked requirement. Because he has so much sick leave, he will be asked to exhaust all of his sick leave accruals, and then for the remaining 4 weeks that he's out, he will then access wage replacement benefits from the Paid Leave Authority using the calculations that I noted earlier. Amy has a different scenario. She works for a smaller employer and part-time, and she's worked there for 2 years. She has only 6 days of sick leave and 3 weeks of vacation time. And she injures herself running with her dog. Applying the same analysis of job protected leave versus income replacement, this is what Jamie's scenario looks like. So because she's worked longer than 3 months, she certainly has job protected leave under the state statute, but none under the federal because she has not met the hours worked requirement because of her part-time status. She then will use all of her sick leave and part of her vacation, but because she is entitled to keep 2 weeks of her vacation, the rest of her wage replacement will come from her application to the Paid Leave Authority. For those employers that have spouses that work for the same employer, there's an important change in the statute as well. Under federal, those spouses are now required to share their 12-week job protected leave if it's for bonding with a newborn child or a child that's new to their family, or to care for a parent with a serious health condition. Under the state current FMLA, that same sharing is required for bonding with a child or to care for a family member with a serious health condition, a little bit more expansive. But under the new leave law, the spouses will not be required to share their paid leave benefit for any reason. So a bit about private plans, which I spoke to just a bit earlier in a few slides earlier. So the way that this works is this, that an employer may offer a private plan in lieu of participating in the state plan, but there is no opting out of the plan unless you are one of the employers in the categories that are exempted that I noted earlier. If an employer chooses to participate in a private plan, they must do so by offering the same or better benefits as the public plan. And their plan cannot cost employees more than the 0.5% that is being collected by the state. If the state lowers its contribution rate, then a private plan must also do the same thing. They must also demonstrate the ability to administer the claims and the benefits to the employees. And finally, they have to hold a vote to seek the employee's approval of the private plan option. And that vote must be participated in by the majority of all employees who work in the state and voting in favor of the private plan. And that includes employees who are out on disability, maybe out on some sort of disciplinary absence, any reason at all. The majority of all employees who work in the state must be able to vote. And finally, the Paid Leave Authority approves the plan. When we approve the plan, your approval is good for 3 years, subject to a periodic review of the plan to make sure that there are no changes that are so substantive that it would require a new vote under the statute. So for those employers that choose to opt into the private plan, there are 3 steps that you should take. First is just to go in right now and register on our website and just let us know whether you plan to apply for a private plan. You are not obligating yourself in any way, and you can change your mind at any time. So you'll be able to go back in and complete a more thorough application, and then you'll be able to upload your final plan documents, and they will be 3. They will be a declaration from an insurer or a surety bond if you decide to self-insure. You'll need proof of a surety bond that's in the amount of the contributions that you will collect from the employees for 1 year. You'll also have to provide to us what is known as the plain language guide, which is something we've created at the Paid Leave Authority, which is a summary of the statutes. We're not asking employers to do that themselves. And finally, you need to give us the proof of your vote, of the majority vote. Once you upload those documents, we will review it and then we will validate you have all of your documents and we will approve your plan. Additional resources that are available to you might be helpful because I've gone through a lot today and I know that there's quite a bit of information. All of this can be found on our website, ctpaidleave.org. On that website, there are lots of things that you can download for your employees. They include an employee rights poster, which is a pretty significantly sized document that's front and back, available. Everything on this site, as a matter of fact, is available in English and Spanish. That gives a summary that's pretty comprehensive of the benefits and the 0.5%. And if you use the QR code that's right here on your phone, it will take you to what is known as a contribution estimator, where a person can actually put in what their estimated income is, and they'll get an estimate of what their contribution will be periodically, depending on when they're paid. The employee rack card is a smaller version of the employee rights poster, but the most important document that we see employers downloading now is this thing that we call the paycheck mailer, which is available to give to your employees to let them know that the 0.5% will be coming out of their paycheck starting January of 2021. Everything that I've spoken of is included in this employer toolkit, which is a 24-page comprehensive guide that explains everything: employer obligation, employee obligation, private plans. It's all available here. And there's also an employee fact sheet that can be downloaded that can be shared as well. That's a single page, front and back, and also available in Spanish and English. So what we're asking employers to do now is to please heed these calls to action. First, please register at the Paid Leave Authority site, which can be found at ctpaidleave.org. And we ask you to do that so that we know that you know that your obligation to withhold is starting very soon. If you are a payroll provider, or if you're an employer that uses a payroll provider, and that can be any kind of third-party administrator, a tax accountant, anybody at all, you should contact them to be sure that they're prepared to process your wage withholdings and remit those to the Paid Leave Authority Trust Fund. I can tell you we've been working with every major payroll provider since April, so they are well aware of this and should be able to assist you. Please educate your employees about the withholding by downloading the information and those documents that I highlighted in the slide immediately previous to this. And those can be found in the employer section of the website. Scroll down to the bottom and you'll see all of those documents. And finally, please visit the site regularly for any updates. And we're here to help you. Please come to the Contact Us portal and please in there put any questions that you might have. And there's also about 150 frequently asked questions and helpful videos that provide information for you as well. With that, I thank you for the opportunity to share our presentation with you today. Let's see if we can answer some questions. And I'll stop sharing my screen.
Okay. Hi, Andrea. Thank you so much for that.
Hi, Amber.
So we have a few questions lined up here. The first is coming from Elizabeth. What happens to any unused money should a self-employed company or one person go out of business before the 3-year statute?
Okay, so it's a pool, so there isn't a refund available, which is why we ask sole proprietors and self-employed individuals who have a 3-year commitment to really take their time to determine whether or not they're going to participate, because there isn't a refund mechanism that's built into the statute as it currently exists. We've heard this question before. We will bring it back to our legislators and talk with them about the concerns that sole proprietors and self-employed people have, but as of right now, there isn't any provision for refund.
Great, thank you.
Mm-hmm.
Next question is, how is the Department of Labor going to be able to handle the extra duties of the arbitration of these leaves?
That's an excellent question. All right, so we've already.
This one's actually a two-part, just so you know.
Okay, sorry. Okay, so do you want to give me the second part, or you want to answer that part first?
Sure. The second part is, how are they going to be within HIPAA compliance requirements?
Okay. So the way that they're within HIPAA compliance requirements is that we have a memorandum of understanding with the Department of Labor, explaining exactly what we can share and what they can share, so that everything will be HIPAA compliant, because we know that's a specific concern. So essentially they'll be hearing grievances around two parts, right? One is when benefits are denied, and the second is whether or not the person was, whether or not their application or their benefits were not properly administered. Those are usually the two large categories in which people will probably make their grievances. So the privacy piece will already be covered through the memorandum of understanding, which will cover how the hearings will be held, who will be able to attend, what information will be able to be shared, how that information will be stored, those kinds of things. So that's the first part. The second part is, how will they handle it? So they won't, here's what we say, they won't really be hearing these things until 2022. So hopefully we will be through the hump that we're in right now, which we all know the Department of Labor, like every other Department of Labor throughout the state of Connecticut, is just inundated with unemployment claims and claims for other types of wage replacement benefits. But they have already been working with us since April to give us a sense of what kinds of staffing they might need, the types of hearings that they may be holding, how often they think they may be ready to hold them, if it's once a week, once a month, if they're going to be hearing them, on the same cadence that they hear unemployment hearings now. So I don't have all of those details right now, but I can tell you that they're well aware that they have this obligation and that we're working with them to make sure that they can manage it, because it's a great question.
All right, thank you.
Sure.
The next question is, are churches required to do the Connecticut paid leave program, especially if the only employee is the priest?
So yes, if it's funny, we've been getting a lot of questions about clergy. If the only employee is the priest or the pastor or the reverend, and they receive a W-2, meaning that they're not an employee that's on contract, or they're not actually a sole proprietor or self-employed, or in some cases, we know that the clergy for a church may be an independent contractor that gets a 1099. So that person can make their own decision about whether or not they come to the paid leave authority. But if they're an employee, then yes, you do have to withhold the 0.5% on their behalf and submit it to the authority.
Great, thank you. Okay, so let's see. What if an employee works for a Massachusetts employer
Mm-hmm.
and normally commutes to Massachusetts to work, but this employee is now working from home in Connecticut?
Yes.
This may be temporary or
Mhm.
permanent. The employer
Okay.
hasn't decided yet.
Right. And I understand that that's an open question for a lot of employers. So that person would be considered an employee in the state of Massachusetts, and they would not be a person for whom you would have a withholding obligation in the state of Connecticut. So we know that Massachusetts has its own paid family medical leave law. You're probably withholding to contribute to that, and that would not change. The residency requirement doesn't apply to employees. So it doesn't matter where the employee lives. What really matters is where they work. So generally speaking, what we tell employers is that if you have an unemployment tax obligation or a payroll tax obligation, and you issue your W-2 for the person for the state of Connecticut, then they're considered an employee and you should be withholding for them. But if you don't, then you don't have that obligation.
Okay, thank you.
Okay.
Next question is, how will determination of leave be adjudicated, and how will differences between an employee and the company be figured out? Is there a simplified process for this before becoming a major review?
All right, you know what? I think I'm going to read that question because I broke up a little bit and I had a hard time understanding it. All right, so let me just
I know. Like,
all right,
okay, let me see if I can get all this out.
All right, how will determination of leave be adjudicated? How will differences between an employee and the company? Okay, is there a simplified process for this before it becomes a major review? Now I understand. All right, so most simplified process that you would have is really having a discussion with the employee. They should be coming to you with certification from their healthcare professional. So it's not like somebody's just going to show up in your office and say, hey, I have a serious health condition and I need to take, 4 or 5 weeks off of leave, and then I'm going to go over to the pay leave authority and apply for leave, and I'll see you later. That's not how it works. So the person has to get a form, or complete an application, which we will be providing. We're not going to ask employers to do that. They have to take it to the healthcare provider and get a certification that will tell them the type of treatment that they're getting, how long they will be away, and when they plan on returning. So that's for the what we call the block leave. So it's a fairly predictable period of time. It may work a little bit differently for intermittent leave. So if someone has, let's say, a health condition that is time limited, but the treatment is something that they have to take 4 hours off a week, twice a week, that would be intermittent leave. And that would also be something that they'd have to get a certification for. So now if you, as the employer, have all of that and the paperwork is returned to you within the time period that it should be, then essentially that person qualifies for the leave. If you have a significant disagreement around that leave, then that's what comes to the Department of Labor, and that's where that grievance is heard. So that is usually filed by the employee, but the department also realizes that there may be some employers that may have a difference of opinion around this. So that we're also talking to them about how that might be handled too. But so that's essentially the process. If the person comes to you with paperwork that's not filled out correctly, or it's not signed, or it doesn't have any of the things that that should happen with it, you can send that person back with a new form or additional form and have them fill that out completely and correctly before you grant the leave.
Great, thank you, Andrea.
Mhm.
Okay, the next question is, would the owner of a C Corp who takes a weekly paycheck like all the other employees be required to contribute and eligible to participate?
That is a great question that we are still trying to get the answer to, because the SCorps and the sorry, did you say C Corp or SCorp? Which one did you say?
C Corp.
C Corp. Okay. So we have some C Corps that are doing exactly, so they have a W-2, they're kind of treating themselves as employees. Under the statute, you're technically an employee and you should be contributing to the fund. We do know that in some states they have treated this differently and they may have some exceptions. So we're actually talking to those states to see if we can really land on what the appropriate answer is, because the statute just doesn't speak to it. The other states, it's more specific around that. So I would continue to look to the site to see if you can get some frequently asked questions. If we get the answer, we will put it in our frequently asked questions, or you can use the contact us feature and let us know. If you want us to know specifically, you can drop your email in the chat and then we will do that research and we'll get back to you directly around that.
All right, thank you. The next question is there a maximum wage base this tax will be based on?
Yes, and it is the Social Security contribution base, which now is $142,000, I believe, $880. So no wages or compensation above that will be subject to the withholding.
Great. When an employee wants to know how their 1/2 of 1% will be treated as taxable, non-taxable, only taxable when they use it, and how will it show up on their W-2?
All right. So we know that we're working with some of the payroll providers. We're hoping that it'll show up on your W-2 under a new box. It'll say CTPL or PL. Not really sure yet. So, each one of the payroll providers has sort of a different iteration around that, but they're working on putting a different box. And I know that is already a very crowded piece of paper. We realize that, but employees have asked us to make sure that we spike that out so that it's not hidden in some other tax withholding. So that will be there. Regarding how their 1/2 of 1% will be used, was that the other part of the question, Amber?
Yes, they want to know the tax basis. Will it be taxable, non-taxable,
right.
or taxable only when they use it?
Okay, so the contribution is post-tax. It's based on the FICA number. When the employee takes their benefit, that is them, but they have the option of having their tax withheld when we pay the benefit, or taking it without the tax, figuring out how they will pay the tax after when they file their income taxes. So that's how the statute reads, is that they have the option of doing one versus the other.
Great, thank you. Is participation
Mhm.
in this program mandatory or voluntary for employers?
For employers, if it's one or more and you're not, as that I outlined, it is mandatory. And that is the way that the statute is designed. And I understand that for a number of employers, this is not what they want to hear. And we get that. But as the statute is currently drafted, it is mandatory for those employers with the exceptions of the ones that I outlined earlier.
Thank you.
Mhm.
Next, can contributions when a single person was in their own LLC be transferred if they are hired by a company and their LLC is closed?
Ah, that is a terrific question. So there's not really a transfer because it's a pool. So it's insurance essentially. So all of the money is paid into a pool and then benefits are paid as people make claims. But what happens is that your wages then are tracked from one employer to another, so we can be sure that you've met that $2,325 threshold. So there's not a transfer to speak of, but there is a tracking of your earnings so that we know that you've met the eligibility standards. So if you do move from working for yourself to going to working for an employer, you don't start all over again with respect to your wage eligibility. That money goes, those earnings go with you essentially as a credit towards the 2325.
Okay. If a sole proprietor's only employee is their spouse, is the spouse employee covered? Like Connecticut unemployment?
Ah, interesting. So yeah, so that spouse is getting a W-2 and they're treated as an employee, then they would be subject to the withholding of the 1/2 of 1%. That spouse would also then be able to apply for benefits come 2022 as well.
Great. And we also have another one. Now, this one's on an S Corp. My husband is self employed. He
Mhm.
pays payroll taxes through his S Corp. Can he opt out from the paid leave withholding?
Yes, he can because he's self-employed.
Great. Okay. If a self employed LLC, one person closes their business, so that I think this is very similar to the one we just answered, closes their business before the 3-year rule, they
Mhm.
tied to the commitment. In other words, would they be required to continue to pay into the system if they were no longer in business?
Ah, so no, if you're no longer in business, then you wouldn't have any revenue to report and you wouldn't be paying into the system anymore. So the staying in for the 3 years, if it's financially infeasible for you, that would be the outcome.
How often do employees receive statements regarding these contributions? Do they
Mhm.
receive direct correspondence or is it the responsibility of the company only?
So the company will be reporting their withholding on the paycheck stub or the statement. None of us really get any paper checks anymore. And we at the Paid Leave Authority will be keeping track of that person's wages. We will not be issuing statements. It's not something that's really feasible for us to do with the numbers of people that will be participating. What we will be doing though is tracking when a person applies for leave, what their earnings are. And we do that by going back to the Department of Labor, with whom we have that memorandum of understanding that not only covers the grievance process, but also covers accessibility to wage data for the purposes of making claims. And because it's a pooled insurance plan, as opposed to, let's say, a healthcare savings account or money that's specifically tracked to that individual, it isn't as if that person has an account that belongs to them. But if they wanted to know, if they just emailed us, or if we hopefully when they have a call center and they call us and say, well, how much have I contributed? We should be able to tell the person that at some point in time. What we can tell them is also how much they've earned towards that 2325.
Great. And we need just a little clarification. For an S Corp shareholder with employees, the person is asking, do they not need to withhold for shareholder employees?
So are the employees getting a W-2? That's really the question, because that seems to be the standard that we are using to determine if a person is an employee. So they're getting an employee has an extremely expansive definition under the statute. So when we talk to the Department of Revenue Services, and the Department of Labor. We said, well, how do you define whether or not someone is working for an employer? And so those criteria that we mentioned, that they're working in the state, that they're receiving a W-2, that they have an unemployment obligation or a payroll tax obligation, that's how they're defining employees. So we are adopting that definition of employee. So if within the SCorp you have people that meet those definitions, then they're employees, and then the withholding applies to them.
Great, thank you. Okay, can you verify the address that withholdings are to be sent to?
Okay. We are not accepting withholdings by mail for a number of reasons. One, we are not in a physical space. As you can tell behind me, I am in my home office, and none of us are back. So there, you can make all of your payments electronically, and you'll be able to do that through the web portal. So the website is a website. It's the place where you register. It's also the place where you apply for private plans. And it's also the place where you will be making your payments. And those can be made by credit card, electronic funds transfer, ACH, any kind of electronic payment that you would make to any other vendor. That's how you would make your payments.
Great. What happens if an employee pays into the fund for several years and then moves out of Connecticut? Will that person forfeit his or her contribution?
Unfortunately, they do, because that is the way that the fund is currently designed. So it is in fact, like other taxes in that regard, that, if we're paying for schools and roads and so on, and, we pay into the general fund and then we move to another state, those resources will not be available to be refunded to us. And the same is true for the contributions to the paid leave trust fund.
Okay. And this one would like to know if you could please go over which types of employers are currently exceptions for participation.
Sure. Actually, if this person doesn't mind, let me go back to that part of the presentation, because it just might be easier to do it that way.
Great. Thank you, Andrea.
Okay. Sure, that's not a problem at all. Let me just get back in here. And I'll share my screen as soon as I get there, because you don't want to see this because it'll just make you dizzy. Okay. All right. Let's see if I can. I think it's a little earlier. Here we go. Okay. All right. So I'm going to go back and share the screen again. All right. So I hope everyone can see my screen now.
You're on.
All right. Terrific. So the covered employers include those that are on the left side, and those are employers that have one or more people working in the state, and that does include not-for-profits and private sector employers that have a unionized workforce. And we've spoken at great length about the sole proprietors and self-employed individuals who can opt in. On the right side are those that are not covered. And obviously that includes the federal government, over whom a state has no jurisdiction. The state of Connecticut, except for those that are in bargaining units, and the same is true for municipalities or local or regional boards of education, unless they too have bargaining units. And the next slide will go into covered public employees. And the category of employer that is always exempt are non-public elementary or secondary schools. Okay, so covered public employees includes all the non-unionized employees of the state of Connecticut. So I've heard repeated very often that it is that the paid leave contributions are ones that have just been imposed on all employers in the state, and the state has exempted itself. And that's not exactly the case. So all non-unionized employees of the state, so I'll be paying into it, and lots of people who are considered non-unionized employees will be paying into the fund. And unionized employees also can do that if they collectively bargain to be included. We often get the question, why is that? And that is because there are a number of different unions and bargaining units within the state of Connecticut, each of whom have a right to collectively bargain for those benefits that they participate in. So in order to be able to do that, those unionized employees will collectively bargain. If they choose to do so, then they will be included in the program. The employees of municipalities and of local or regional boards of education, those unionized employees of the municipality also have that same right, and they can collectively bargain to be included. But if they do, the difference here is that in the municipalities and the local and regional boards of education, if the union and those unionized employees vote to collectively bargain to be included, then that decision is binding on the entire workforce, whether they are union or non-union. So I hope that answers the question.
Great. Thank you so
I'll
much,
stop here.
Andrea.
Sure.
So that concludes our questions. So I would like to say thank you to everyone for joining us. Jackie, Luke, do you have any comments that you'd like to add?
Luke or Jackie?
Yeah, thank you, you too. I think this was extremely helpful for all of our small business owners here. I know it was a lot of content. So I did see that Amber had posted that everybody is going to be getting an email in about 48 hours, including links to a lot of these helpful points to help answer a few more of your questions if you have any. So thank you to very much for hosting us and helping explain all of this to our business owners.
You're very welcome. Thank you. We appreciate the opportunity to be here.
All right, yeah, thank you. Have a great day.
All right, thanks. Bye.
Thank you. Bye-bye.